So the symposium today focuses on the U.S. Supreme Court's 1964 landmark decision of New York Times versus Sullivan, which held that the First Amendment's protections for the freedom of speech and freedom of the press limit the ability of government officials to sue for defamation. So our panel is going to focus on the Supreme Court's decision and the legal framework that it created. And we're going to cover three broad topics. First, we're going to set the stage by discussing what the court decided in New York Times versus Sullivan in later cases. Second, we're going to talk about the objections that Justice Clarence Thomas and Justice Neil Gorsuch have recently raised about New York Times versus Sullivan. And then last, we're going to talk about where defamation law might be going and what effects those changes might have. So to kick things over to the panel and to set the stage for the discussion, what is defamation, generally speaking, and how does it relate to the Supreme Court's decision in New York Times versus Sullivan?
Oh, that's an easy question. I'll happily take that one. I haven't had all my caffeine this morning, so I figured I'd jump in early. So when I talk to students and journalists and attorneys about defamation here in the United States, I often talk about defamation being a false factual statement that injures someone's reputation. Now, internationally, that's not necessarily true, and as we'll talk about before New York Times versus Sullivan, that wasn't always necessarily true. But today, when we're thinking about defamation, we're thinking about a plaintiff having to prove that a statement injured their reputation by identifying them and saying something that was a false fact that caused the injury to that reputation. New York Times versus Sullivan introduces what we might think of as the interesting element of fault. Prior to New York Times versus Sullivan in 1964, defamation in most instances was a strict liability tort, meaning liability without fault. So intent didn't matter in many instances. New York Times versus Sullivan, of course, changed that by saying that the First Amendment protections for freedom of expression require some level of fault to be shown. And in the instance of New York Times versus Sullivan, which involved a government official in Montgomery, Alabama, we have a situation where the court has said that level of fault needs to be actual malice, which I would argue is perhaps one of the most misunderstood legal concepts that we talk about today.
So, and we'll jump back into what actual malice is in a moment, but maybe let's just talk a little bit more about the case itself. So what was going on in New York Times versus Sullivan?
Do you want to take it or should
Sure. So New York Times versus Sullivan came at a time when defamation was a common law tort. It was a kind of common injury. It was created, really, research has shown in some ideas, to prevent duels. Enter the civil rights movement. We have a major national debate about race relations in the United States. We have an increasingly powerful press. The New York Times is now becoming a national newspaper. And you have basically this fight to capture the public opinion of Americans when it comes to giving Black Americans greater rights. In the early 60s, there was an advertisement that was placed in the New York Times that discussed police, basically brutality against civil rights leaders, including Martin Luther King Jr. It talked about how he had been arrested 7 times. It talked about how protesters had been ringed around a campus. And this wasn't even a news story, which I think is a common misunderstanding. It had some factual errors in it. For example, Martin Luther King had only been arrested 4 times as opposed to 7. While there had been brutality against protesters, they weren't ringed in the way that the advertisement described. So the police commissioner, who was not named in the advertisement, ends up bringing suit. The argument was that this was damaging his reputation. Never mind that there are arguments that this was actually helping his reputation in his own community. So it ends up going to court. And if there's $5 million in damages, which is a huge amount in today's dollar. Meanwhile, the New York Times is now facing potential liability for all sorts of suits like this, upwards of $300 million. So it's now this fight where you could potentially bankrupt this news organization if you can win on these judgments. And it became untenable, essentially, in the eyes of the Supreme Court to have a situation where you were effectively censoring the press, censoring news organizations from covering civil rights issues of the day just because they got a couple of errors wrong.
So what does the Supreme Court do with the decision, and what's the reasoning that the court uses to reach that conclusion?
Sure. So I'll just add a little addendum, because there's one case that we don't often think about when we talk about New York Times versus Sullivan, which is Abernathy versus Sullivan. New York Times versus Sullivan is often thrown into this political debate about the press is right or left or in between or what have you. But New York Times versus Sullivan is not a case about press freedom. At least it's not only a case about press freedom. There were 4 black ministers whose names had been added to the bottom of the advertisement as if they were signatories. They did not know that their names had been placed on the advertisement. They too were sued by the commissioner. They brought their case to the Supreme Court with the New York Times. It was consolidated under the name New York Times versus Sullivan. But the reason why we should not forget that the 4 black ministers were also parties in the lawsuit is that number one, they did not have, even though the lawsuit could have bankrupted the New York Times, they did not have the same kinds of resources that the New York Times had to fight the case. Their land was taken, their cars were taken, their bank accounts were emptied. After the Supreme Court reversed, they had to go to the trouble of trying to get their money back. So I think that one of the things that we often forget is that while we sit here in a journalism school and we talk about New York Times versus Sullivan, this is not a case about journalism. This is a case about every citizen's right to be able to speak on matters of public concern. As to the specifics of the question, so I think to kind of unpack actual malice a little bit, what the court said there was that the commissioner could not prevail in his lawsuit absent a showing of actual malice. What the heck is actual malice? I don't know. But what the court said actual malice is knowledge that the defendant made the statement knowing that it was false, or with reckless disregard as to whether it was true or not. Now, that begs the question, what the heck does reckless disregard for the truth means? I don't know. But what the court would later say is 2 separate formulations. Either that the speaker had serious doubts as to the truth of the statement, or alternatively, that the speaker made the statement with a high degree of awareness of its probable falsity. I think we can boil this, now that I've said I don't know what all those legal things mean, I think we can boil this down to one question. And the question that every plaintiff, every public official plaintiff in a defamation case must answer is whether the defendant knowingly lied, whether there was a calculated falsehood. So all Sullivan does, for all we talk about Sullivan and all the effects it has had, it basically just says, you can't knowingly lie about someone. So long as you're not knowingly lying about someone, you can't be held liable for damage to their reputation as a result of what you said.
And why does the court draw the line there as opposed to somewhere else?
So, or do you want to
Go for it.
So, it's how the case was briefed, is the short answer. There was indeed a common law. So before 1964, there was a large amount of jurisprudence that had developed in state courts dating all the way back to the early 1800s that had homed in on that fault question. And Justice Brennan, who wrote the unanimous opinion for the court in Sullivan, drops a footnote, says this rule is much like the common law rule that had developed in the states, and we're essentially just constitutionalizing that part of the rule. But there was concurring opinions in Sullivan suggesting that maybe fault was not the proper inquiry. Maybe we should put defamation lawsuits brought by public officials, just completely throw them completely out of court. Basically, we live in a representative republic. Public officials should not be able to sue citizens for saying bad things about them. So there were at least some votes on the court for saying we just shouldn't entertain these at all. There were subsequent proposals, some of which were adopted by the court, saying, well, maybe we should put limitations on damages. They tied those to actual malice, but there were also other proposals that said, well, what if we just provided declaratory relief? So what does declaratory relief mean? Essentially, you don't get damages, but you can get a declaration from a court that a statement was false. So there's all sorts of ways that the court could have gone about protecting freedom of speech. They ultimately settled on this one, and I think we could have, a 3-hour debate on whether Sullivan was right on that basis. But I'm not a justice. So.
So how does the court then build on New York Times versus Sullivan going forward? Because Sullivan itself focuses on a government official, but the court later expands it beyond that.
Absolutely. So the court goes on in a series of cases after Sullivan to apply the actual malice standard to what the court terms to be public figures. And eventually, in Gertz versus Welch, we get some idea that there are actually multiple categories of these public figures. So we're thinking about folks who I might say are household names as all-purpose public figures. We're thinking about celebrities, athletes. And the court chooses to include public figures in this actual malice standard because ultimately the court finds, one, that they have a pretty important role in our society. They have the ability to influence policy. We now know, of course, in the age of social media, that some people make their electoral choices based on who a particular celebrity or well-known influencer on social media has said they're going to vote for. And I think the court had a little bit of foresight to think about this in the late 1960s, that there were these people. In communication, we often refer to them as sort of being community influencers, and we think about opinion leaders in our community. In the 1960s, we might have thought about those as being prominent religious, members of the church. We might have thought about that being local politicians who were, use politicians, local folks who maybe weren't elected to certain positions. But so the court goes on to then widen out this actual malice standard to apply not only to public officials, but also to public figures. We get into Gertz, and this is, I think, where some of the folks who have issues with the actual malice standard begin to get concerned. Because although we might all agree that there are certain folks who are all-purpose public figures, there are also instances where someone becomes a public figure, becomes, centered in the news by no choice of their own. And Gertz and subsequent cases and scholars have thought about this as the involuntary public figure, right? I'm old enough to remember Elian Gonzalez. Some of you in the room might remember that case of the little boy who, in Florida, whose story was brought into the news. Another person we might think of more recently would be Dr. Blasey Ford and the confirmation hearings. These are people who perhaps never intended to seek the limelight, who perhaps don't have the same access to media or to rebut statements about them that a celebrity athlete or a movie star or a public official would have. And so I think that's where we get into some of the real concerns about the standard.
So when we think about the First Amendment, I think we usually think that one of the main purposes is to help advance the search for truth. And by setting the standard as basically requiring a knowing lie, these rules are in fact sometimes going to protect false statements about these public figures. So why is the court not more concerned about that? What's the worry there?
Well, so you hear the terms chilling effect and breathing space discussed a lot when it comes to the First Amendment. And the idea is that if people are so afraid of making a statement of, in the context of journalism, reporting a fact, and then getting it wrong, and then being sued potentially for vast amounts of money, then they're not going to do it at all. They're going to curtail their speech, they're not going to engage in public debate, they're not going to report on important issues, they're not going to express their views on important matters of the day. And the idea behind basically constitutionalizing defamation law, in my view, is in large part motivated by this concern that we need to have this freedom to occasionally make mistakes when we're communicating about the important issues of the day, to have a functioning democracy. And that was part of the whole reason that we have protection for freedom of the press and freedom of speech in the first instance.
Yeah, and I completely agree with that. And having sat in a newsroom working with journalists deciding whether we've got it right, one of the frustrating things about kind of all of the boogeymen that we get out of the New York Times versus Sullivan debate is this idea that journalists are out there just saying, oh, it's close enough, right? Which is, at least in my experience, not at all true. I've never been in a newsroom having a discussion with an editor and a journalist and everyone agreeing, we might be wrong, but we've got New York Times versus Sullivan. It just doesn't happen. The idea of a newsroom is to tell truthful stories about matters of public concern. And responsible newsrooms simply don't kind of like throw caution to the wind and say, to hell with it, we'll just see what happens and maybe we'll survive on the actual malice standard. I query how many journalists have really given actual malice a thought even, right? All the lawyers sit around and talk about it like it's this thing that hangs over everything. But I think in practice, because Alexandra's exactly correct, the response to the criticism that, well, doesn't this just create more falsehoods in our information environment is just detached from how the news works in a newsroom.
Yeah, I would completely agree with that. I was a journalist for 7 years before going to law school, and the only time I thought about Sullivan before going to law school was, maybe on the annual newsroom training where you have a lawyer come in for 15 minutes and brief us. You're so much more concerned about as Matt said, getting it right and the ethics of being a good reporter, and also the embarrassment of having to file a correction, that you're not going to go out on a limb and report out something to be false.
So I think this is a good segue to some of the criticisms of New York Times versus Sullivan. So in 2019, Justice Clarence Thomas wrote an opinion arguing that the Supreme Court should reconsider the decision. And he says the following: New York Times and the court's decision extending it were policy-driven decisions masquerading as constitutional law. We should not continue to reflexively apply this policy-driven approach to the Constitution. Instead, we should carefully examine the original meaning of the First and 14th Amendments. How would you respond to that?
If you know Matt, you know he's a history buff, so I'm gonna defer to Matt on this one.
So, few things. So he's, I think there's first the question of whether or not we should base what we think the First Amendment means today on what James Madison thought in 1789 when he first, on June 6, 1789, when he first introduced what became the First Amendment. I don't much care what James Madison thought the First Amendment was supposed to mean, and I don't think that James Madison would much care if we, adjusted or kind of imprinted onto the First Amendment as citizens in this country, the meaning that we need to serve the problems that we presently face. So that's the first point. The second point is, Justice Thomas said, well, at common law in the 13th and 14th centuries in England, there was this, it was actually a trio of statutes called Scandalum Magnanum, and in fact, defaming public officials under these particular statutes was seen as worse than defaming private persons. So in fact, maybe it's hidden somewhere in the First Amendment or of the press or freedom of the speech or freedom of speech, excuse me, is this idea of scandalum magnatum being transplanted, from 800 years ago to present. I find that completely preposterous. But I'd also say to Justice Thomas, if that's the version of the First Amendment, the punishments for scandalum magnatum for slander, that is spoken defamation, was to cut off someone's ear. The punishment for libel was to cut off somebody's hand. So if we're going to be originalists about it, well, let's go all in, I guess. And then the third point, one of the arguments that we get from Justice Thomas and other leading opponents of Sullivan is this idea that really what the First Amendment meant at the time it was adopted was this kind of traditional British idea, English idea, that really all the First Amendment was meant to protect against was what are called prior restraints. Prior restraints are simply prohibitions in advance of speech, right? So you stop someone from speaking. There's just no support for this. Oftentimes, folks like Justice Thomas will cite to William Blackstone, kind of the great English commentator. There's all sorts of correspondence between the founding fathers on freedom of speech and Blackstone saying like this can't possibly mean Blackstone can't possibly be what we mean by the First Amendment or freedom of speech in the United States. And just to wrap that point up, in the Sedition Acts, which Justice Brennan references in Sullivan to support his kind of, originalism was not as big of a thing in 1964, but Justice Brennan nevertheless cited the Sedition Act. It was a law that was passed by the Adams administration to keep Adams in office in the run-up to the election of 1800. As a result of the Sedition Act, Jeffersonians were tossed in jail, it ultimately failed. Obviously, Jefferson won the election of 1800. But the reason why I bring up the Sedition Act is there's discussions in Congress at the time, and one of the leading Democratic Republicans stood in opposition to the Federalist argument that the Sedition Act was constitutional because all the First Amendment means is a freedom from prior restraint. And he said, I think quite simply and persuasively, the First Amendment is phrased in freedom of speech or of the press. Prior restraints historically had only ever been imposed on freedom of the press, not on freedom of speech. Why is that? Well, as this particular representative said at the time, he said, there is no way to put a prior restraint on one's speech. What would you do? Cut out my tongue. And I think that's just another piece of evidence in a vast constellation of evidence, contrary to Justice Thomas's very selectively picked, historical nodes, that undercuts this idea wholly that somehow, this was just like make-believe on the court's part in 1964.
So one of the other things that Justice Thomas points to is historical practice after the First Amendment is adopted. And he argues that public officials and public figures continue bringing civil libel suits without a requirement of actual malice for a good long period after the founding takes place. Do you think he's wrong about that too?
Yes. Should I?
Go for it.
I don't want to. So, as early as 1803, 1804, courts start putting intent in play. As early as, I believe it was 1808, in a case called Lewis versus Few, defense counsels start arguing for an actual malice standard. So this is what, we're 17 years past the First Amendment at that point. It's also pretty impressive. I mean, we've kind of ignored this up to this point, but Justice Thomas says, well, there's not evidence that the First Amendment meant X, Y, or Z early on. But of course there's not. When the First Amendment was adopted in 1791, obviously it applied only to the federal government. Defamation is a state law claim. So this idea that I think that there's plenty of evidence to support the general idea that freedom of speech included something like actual malice, but to say, well, there's no evidence that actual malice was understood as part of the First Amendment as a limitation on defamation claims makes no sense because the First Amendment was never understood as a limitation on any state law claim. But to get back to the question, by the 1830s, courts are accepting in the context of public officials. They are accepting an actual malice fault standard. It is in the context of a privilege. So courts say, hey, we live in a Republican form of government here. It's important that citizens have the right to criticize their representatives in government. They have a privilege to speak about public officials' public conduct. And the only way to overcome that privilege is for the public official to show actual malice. Again, that's as early as 1830. You get closer to the Reconstruction, that those ideas continue to proliferate. Granted, I'm not going to be as disingenuous as Justice Thomas was. They remained a minority of those cases, but that just begs the question of, history is not a monolith, so, which side was right. But by the time you get to the 1860s, 1870s, you have courts extending to public figures the actual malice requirement, usually in the context of individuals who are private figures but contracted with the government to provide a service. There's a great one, Bangor, Maine wanted a new courthouse, bad limestone. The limestone provider decided to sue because the local newspaper, whoever it was, said, this guy doesn't know how to go quarry good limestone, which I guess that hurts your reputation in 18 whatever it was. But you see those cases, the public figure cases start expanding as well into things like railroad barons being required to show actual malice. Again, this is all in the 19th century. I don't think any of it matters, to be clear. I don't think we should have to go back and look at all of this stuff, but if that's the way the court's headed as far as imposing this kind of originalist limitation on the First Amendment, which happens only to be consistent with conservative views of prevailing issues in today's society, I just think he runs into too much contrary historical evidence that you just can't explain away.
So, let's set aside whether Justice Thomas is right or wrong. Usually the Supreme Court won't overrule a precedent just because it's wrong. The court will look at other factors like whether the rule is workable, whether people have relied on it, whether later developments have undermined the rule, so on and so forth. And I think this is where Justice Gorsuch's opinion comes in. And so Justice Gorsuch tries to argue that later developments have undermined the rule that New York Times versus Sullivan adopted. And he points to three things in particular. I want to lay them out one at a time and then get the panel's reactions. So the first is that he argues that the amount of misinformation in the world has skyrocketed. So he argues in 1964, you've got a small number of companies that really dominate the press. It's very expensive in order to publish newspapers, and so you have a limited number of companies doing it. And these companies tended to employ investigative reporters, editors, fact checkers, so the news is fairly reliable. Today, with the advent of the internet, virtually anyone can publish anything at any time, and it can be consumed anywhere. And so he argues we've transitioned away from larger, reliable companies. They may still exist, but there are also 24-hour cable news companies and online media platforms that will say anything to get clicks. And so he says that has drastically increased the amount of misinformation in the world and made New York Times versus Sullivan a lot more costly than the court would have thought. How would you respond to that?
Well, I might be jumping ahead of things, but this is why I don't think the court is going to overrule Sullivan or really...
Oh, no, you gave it away.
I know. If you read his dissent from denial, the very end is, I don't know what the answer is. I don't know what to do. Sullivan is such an entrenched opinion at this point, and I leaving aside Roe and Dobbs, which we may also get to, and the willingness to move away from precedent, usually I think you have to have at least some semblance of an answer and some point of disagreement, point of agreement, and getting rid of the actual malice rule. And I don't know what the court would even think of replacing it with. And I think that there you still have at least half of the court who would be willing to uphold it. You only have two justices right now questioning this. So the idea, and I'm bringing up a number of points with regard to his dissent from denial, but I just feel like there was just so much mixed in with there. It's a total policy position, and he seems to be kind of confusing platform liability and freedom, Twitter's freedom to remain free of lawsuits through Section 230 with the First Amendment. So given that, I don't know how much there is to really respond to ultimately to that point, except he seems to be dissatisfied where things are. And I agree that there is a lot of misinformation, and we do have difficulty having a healthy and successful and honest discourse, but I don't think that Sullivan is the problem here for that.
And these are maybe related to the topic but unrelated to one another points. The first is query whether, as a percentage, we have more misinformation. We certainly have more information. And so to say that we have more misinformation, I think also has to account for the fact that we have an unprecedented amount of information today. Now, there's always been misinformation. There's always been false statements. We've protected that. I think one of the things that troubles me about what Justice Gorsuch says is, I'm going to be a little flippant when I paraphrase how I hear him. It was great when only the big, powerful companies owned by elite, rich white men were the ones speaking. But now that we have the internet and other people also have an inexpensive way to get their views out to the public, it's dangerous. There is fundamentally a power dynamic that has to be considered, and the New York Times versus Sullivan decision protects the press, and it protects the average person, the average citizen, who now has the ability to criticize their public officials and their government in ways that they have never been able to do and reach audiences that they have never been able to reach before. I'm all for that.
So to try to put Justice Gorsuch's argument into the best possible light, I think I don't.
It's going to be difficult.
I'll do my best. So I think at the end of the opinion, he does suggest he doesn't know what the answer is. I suspect that is partly because this is a dissent from denial, and he wants to at least preserve the appearance of being open-minded when the case comes back in the future. I suspect that he would say, well, you have a lot of disinformation out there, so the solution is make it a little easier for people to sue to remedy the harms of that disinformation. Do you think that doesn't help?
I mean, it's kind of interesting right now. There is a lot of, I would say, movement against having platforms regulate speech, and this would seem to say, okay, well, we don't want the platforms regulating speech, we want the courts to regulate speech. What would that look like? We're now talking about, as Amy was pointing out, massive volumes of information and misinformation. I don't know how many tweets there are per day on Twitter and how many of them could be arguably defamatory, but I don't think the courts have any interest in taking on every single lie that you see from either a cranky person or whether they have power or not. I don't know that changing the standard of whether someone knew it was false is really the answer for that either. I think there are other ways that you can promote more truth in our discourse, encourage people to be more fact-oriented, discourage lies. Matt was mentioning the declaratory judgment model that was kind of kicked around. I think that is, if your concern is there was a lie out there, I need to correct the record, well, maybe making it so you go to court, you don't have to go through discovery, which is a very expensive process where you can be questioned for 7 hours by an attorney on what you knew and didn't know. You don't have to turn over your notes, which is very important to reporters. I think that might do more good than necessarily upending our doctrine entirely.
I also just want to say, so I obviously have opinions. today, the opinions are my own. But I do want to say I had the privilege of representing the defendant in the case that Justice Gorsuch issued that opinion. And one of the frustrating things is that a lot of these discussions are happening kind of in the abstract, in these denials from certiorari or dissents from certiorari or concurring in denials of certiorari. And Justice Gorsuch's opinion in that case is completely unresponsive to the record. It is it's essentially the equivalent of a judicial op-ed. It has no precedential basis. It's completely unengaged from, as I said, from the facts and the record. And I think that it is a disservice to discuss these issues in the abstract because it doesn't allow, he didn't have any answers because he wasn't thinking about a specific issue in front of him. And I don't know that these kinds of like glancing attacks at Sullivan beyond, signaling to, I guess, the plaintiff's bar that, hey, maybe you should keep trying, does anything to advance the law, and in fact, it probably does more violence to the law.
Well, let's talk about a couple of the other points that he makes and get your reactions to them. So one of the other arguments that Justice Gorsuch makes is that the test, the New York Times versus Sullivan test, applies to a lot more people now than it used to. And we've already kind of touched on this a little bit. When the court first decides New York Times versus Sullivan, it applies only to governmental officials. And later, the court expands it to public figures. And now we live in a world where private citizens can basically become public figures overnight. And so, again, he argues this increases the cost of New York Times versus Sullivan because now, instead of applying to a very small number of people, it's actually applying to virtually everybody. What do you think about that?
I think there's a really great answer to Justice Gorsuch. I argued for it in 2014. Great. Let's return to, instead of making this private-public figure distinction, let's return to applying actual malice in any case that involves a matter of public concern. If that's what we're really trying to protect, discussion of issues that are fundamental to the governance of the society that we live in, there you go. If you're a citizen in a Republican form of government and you want to talk about a matter of public concern, you should get the protection to do that.
Mm-hmm.
I also think it's kind of divorced from the reality of libel law today. I mean, your average private figure who's just going about living their life, these aren't the people who are bringing lawsuits. They're definitely not the people who are bringing, these sort of catastrophic libel lawsuits against news organizations. The reason they're not bringing lawsuits, I don't think, is because of the Sullivan standard. It's because bringing a lawsuit is, expensive and time-consuming and can be emotionally difficult, and most people just move on with their lives.
And I will just add, in New York for the last 2 years and in New Jersey for many years before that, there has exactly been that standard that actual malice is required in any case concerning matters of public concern. People still have reputations in New York. Maybe not good ones, but they have reputations. Same thing for New Jersey. Probably worse reputations, but they still have reputations. So, like, the idea that, if we were to extend this, consistent with Amy's argument, that somehow that would, I guess, no one would have a reputation anymore, or there would be chaos in the streets. It's not at all credible.
So the last argument that Justice Gorsuch makes has to do with how strict New York Times versus Sullivan actually is. And when the court first adopts it, the court thinks of it as being a high bar. But over time, he argues, it's basically evolved from a high bar into an impossible one. And Justice Byron White previously referred to this as an almost impossible standard to meet. And if you look at some of the statistics that Justice Gorsuch cites, he says over time, trials involving defamation have basically dwindled to nothing. Back in the 1980s, you had on average 27 per year. In 2017, you had 3. And most of those are unsuccessful, and even the ones where plaintiffs are successful, only a third of jury awards in favor of a plaintiff actually survive on appeal. So he says New York Times is basically impossible to meet, and it's basically killed the defamation suit.
Except if you look at the past year, there have been so many defamation trials. We've had the Palin trial, we've had the Johnny Depp and Amber Heard trial, we've had, admittedly this was a damages trial, but we've had the Alex Jones, Connecticut, and Texas trials. Cardi B, it's something where people are making it to trial now, and I don't think it was really the standard that changed things in the first instance. I was talking about the burdens of discovery earlier. I think that, oftentimes it's because you end up with a lot of unmeritorious suits getting kicked out at the motion to dismiss stage. And then once you get to the point where, okay, we're going to have to really wrestle with the question of actual malice in discovery, oftentimes these things will settle or, get resolved at the summary judgment motion.
Well, and let's be clear, I'm not the practicing attorney here, but pleading standards have changed since New York Times versus Sullivan. So there are lots of cases now that don't meet the standard of Iqbal and Twombly out the door, right? Having to plead actual malice is a challenge. That is not, the change in pleading standards is separate and distinct from Times versus Sullivan, right? So there are other procedural matters, anti-SLAPP statutes and the development of anti-SLAPP statutes. There are other reasons aside from the fundamental principle of actual malice established in Times versus Sullivan that these cases aren't getting to trial.
So Justice Gorsuch and Justice Thomas are obviously making these arguments from the right. But over the last few years, I think we've seen a growing recognition from a lot of different areas, especially on college campuses, that speech really can cause serious harms to people. And it's hard to argue that defamation causes real harms to the individual people who are defamed. And misinformation can cause harm to the political system more generally. And I think that's something else that we've seen a lot of in recent years. Should any of that affect how we think about the New York Times versus Sullivan standard?
How so?
Should it make us more sensitive to the harms that might be being caused and think about changing the way that we allow people to respond to them?
So I don't know if this is horribly responsive, but I'll say it anyway. I think that we have to remember that there are harms on both sides of the V in these cases. And oftentimes, defamation plaintiffs are looking for a windfall, or they're just looking to punish the person who said something bad about them. And again, I want to just continue to harp on this idea that this should not be a political issue, that this should be a civic issue. It is not just the media. It is individual, folks in their communities who want to criticize their police chief, for example, and then they get hailed into court, spend years in court. Maybe that they have defamation coverage under their homeowner's insurance. I don't know. My dad's here. He's an insurance agent. He can tell me. This is. I don't think we can discount just how damaging these sorts of defamation lawsuits can be for the defendant, and I think more damaging than what the plaintiff has to suffer. Just to give you a few examples. These are just articles I grabbed this morning, brief Google search. Cincinnati police officer sues for defamation over protests on social media. Weirden police officer sues organizations, individuals on defamation allegations over Halloween display comments. Court allows officers to proceed with their defamation claim based on city council members' statement. Brett Favre sues state auditor for defamation of character in Mississippi welfare fund scandal. Do we want all of these sorts of localized controversies to just be gummed up in court for years and years and just ruin people? To me, that just makes no sense, at least in the form of government that we have.
And I'm going to go back to the power differential again and talk about the fact that when we're thinking about damages allegations that have now crossed into the billion with a B dollar mark, We're talking about the potential for a plaintiff to bankrupt an individual, a family-owned news organization, right? We've seen this happen already with Peter Thiel funding Hulk Hogan's lawsuit against Gawker. Now, listen, you may not like Gawker, that may not be your cup of tea, but having a plurality of media organizations is beneficial in a democratic government, in a democratic society. And so maybe you don't like Fox, maybe you don't like MSNBC, maybe there are magazines that you wish weren't publishing, but the very fact that we are at a threshold now in terms of damages where we can start to put media organizations out of business because we don't like what they're saying, that's a real problem when we live in a country that purports to value freedom of expression.
And I think in some ways when we talk about this, we can add, giving the plaintiffs as much benefit of the doubt, we're talking as if every single case involving a statement, the statement is actually defamatory. In many of these cases, they're not. It might be hurtful to call someone sexist or racist, but under doctrine that's not being questioned, that's treated as opinion, and you still have to defend against that. Or you could have a situation where someone is mentioned in passing in a news story or in conversation, and they don't like what's said, and they can end up manufacturing a claim. If it were something where every single defamation case were a meritorious case, I might feel differently. But I've just seen so many cases where it's just a complete waste of time and money for the individual or the organization defending against it. And it's clearly meant as a nuisance. It's the whole reason we have this concept of strategic lawsuits against public participation, SLAPP suits. It's a very effective tactic to file a complaint, pay $400 in federal court or whatever it is in your preferred state court, make an individual or a news organization go through the trouble of hiring a lawyer, respond, delivering an answer, filing briefing, and then potentially having to go through the burdens of discovery to get them to stop talking about you. And I don't think that's good for society.
And there was just a case recently in Ohio that was dismissed after 2.5 years that was brought against several citizens by a police officer. And there, the police officer sued under as a John Doe, so he didn't want to, put his name out there in the court record. He then sought, or his counsel sought, a temporary restraining order to prohibit these individuals from speaking. And then 2.5 years later, after it goes up to the Ohio Supreme Court, I think maybe a couple times, finally the case is dismissed, like all over, what should have been a flash in the pan, frankly.
And what you're talking about is actually the chilling effect in action. And having worked in a newsroom that was facing a significant defamation lawsuit, I can tell you it impacts how journalists do their jobs. It impacts how the copy desk does their work. The journalists who had been named in the lawsuit when I was in the newsroom were nervous and were scared and were afraid to report on the things that they needed to be reporting on in the community because the news organization had been sued by a wealthy developer. And that fundamentally alters the kind of information that gets to the public. And I think that's really, really troubling.
How do other jurisdictions, other countries approach these issues? And if they don't have something like the New York Times versus Sullivan standard, do we see evidence of this chilling effect there?
Absolutely. So when you think globally, there are a number of countries in which truth is not a defense to a defamation case. Going back to what Matt was talking about when defamation against government officials was seen as worse or more damaging. That's the case in many countries where there are special laws. I lived in the Middle East for 5 years. There are all kinds of laws on the books throughout the Middle East that are designed to protect the reputation of the ruling family, of the state religion, right, protecting Islam. You see blasphemy laws in other countries as well. I mean, I don't want to say that we are exceptional in that we have actual malice, because there are other countries that have similar heightened standards. And we're seeing countries, particularly some countries in Africa, particularly some countries in South and Central America, that have developed actual malice-like standards. But you certainly don't see, in all instances, the kind of robust journalism that you see here, or you see journalists like Maria Ressa in the Philippines, and journalists who are in Hong Kong right now trying to cover the national security law, who are constantly under threat of being jailed or who are facing lawsuits and still trying to do their jobs.
Or they're just killed.
Or that.
So let's look forward a little bit, and we've had one prediction so far about what's going to happen, but let's keep everybody on the edge of their seats and save the rest of them. Let's talk a little bit about some of the efforts that have been, legislative efforts that have been made to get New York Times versus Sullivan back in front of the Supreme Court. Does someone want to talk a little bit about the Florida legislation?
Preference.
I'm going to stay quiet on that one.
So in Florida recently, there were two bills were filed in the State House. It's HB 991, and I don't remember what the Senate bill number is, but at any rate, these laws are attempting to set up a conflict between state law and Sullivan to put that issue back before the court. I think that it is likely that we will see more of these laws being passed in states that view this as a media issue, as a political issue, which for all the reasons I think we've been discussing here today, it is not just a political issue. But these laws are basically attempting to either say redefine actual malice or just writing actual malice out of the books, but because there is indeed a supremacy clause in the U.S. Constitution, those laws would conflict with prevailing interpretations of First Amendment law in cases like New York Times versus Sullivan, and at least significant portions of them found unconstitutional. But again, that is the point, to set up these conflicts. We saw it with Roe and Dobbs, and it looks like that's the same sort of playbook that folks who, again, view this, unfortunately, through a political lens, are going to run.
Can I talk for a moment about that more broadly? Living in a state that has a legislature that likes to pass patently unconstitutional legislation. Fundamentally, this is a problem that all citizens should be concerned with for a number of reasons. A lot of this legislation right now is aimed at targeting our First Amendment rights, whether that be religious rights, whether that be speech rights, whether that be press rights, whether that be assembly rights. A real problem that a lot of us don't often think about, but I lose sleep over, is the fact that when state legislatures pass these very clearly unconstitutional laws, time and resources have to be dedicated to fighting those laws, and fighting those laws in multiple states on multiple fronts. And in the meantime, your taxpayer money is being used by the state to defend those laws, and attorneys like Matt and Alexandra and Lita and others are having to step in and try to take those laws on. I think it's really important to acknowledge that on both sides of the aisle, we have lawmakers, not all of them, who act in bad faith. And I think that's a real unfortunate problem when it comes to fundamental rights and civil rights like freedom of expression and other First Amendment rights.
And I'll just add, Thomas Cooper, who Thomas Jefferson once called the greatest man in America, he once said that the doctrine of libel is a doctrine of power. He actually didn't say it. He was quoting another case, but it's a better story because I get to mention Jefferson. And I think that, so he said that back in, or reprinted that back in the 1830s. And I think it's important when we're thinking about attacks on Sullivan, whether they be judicial, legislative, or otherwise, to keep that in mind, because it seems to me that really this is not about, we might dress it up as, well, this is trying to protect, the random Joe or whoever on the street and his or her, Josephina, his or her reputation. I just don't think that is the motivating force behind a lot of this stuff. Instead, why I think Sullivan has gained the attention of so many critics is because through the use of libel law, you gain power, right? We've been talking about that today. You have the power to shut down your critics. If imposed for long enough, right, you have the power to actually bend the public discourse and bring it to heel, essentially. And that's exactly what we saw in the run-up to New York Times versus Sullivan. L.B. Sullivan, who was the plaintiff in that case and commissioner, as was mentioned earlier, he and several other powerful individuals in Alabama, powerful politicians in Alabama, they all got together and they decided, well, look, we can use libel law to essentially keep outside agitators from contesting the continuation of a Jim Crow South. And it was a coordinated attack. That is why the libel verdicts libel verdicts that had already been handed down and the ones that were on the way were so large, because every politician was suing because they thought that their reputation was harmed. In fact, L.B. Sullivan put on multiple witnesses who said that the advertisement in no way affected their view of his reputation, right? There was no actual harm. He never attempted to prove any actual harm. It wasn't about harm to his reputation. It was part of a coordinated scheme to control what citizens are able to talk about in a Republican form of government. And that is, I think, the more worrying thing that I'm starting. It seems like we're maybe headed back to that place.
Yeah, and it's not just about extracting pain from news organizations. I think it's also about sowing distrust of what you're hearing. If you're saying they're lying about me, they're lying liars, then why should anyone trust the organizations that I'm suing?
So just briefly, let's talk a little bit about the scope of these challenges and maybe comparing it to Roe is an interesting analogy, because there you obviously had lots of states over periods of decades repeatedly passing laws designed to test the Supreme Court's decision in Roe. How much of this kind of legislation are we seeing, like the Florida legislation, trying to set up these challenges?
So I'm only aware of the Florida one right now. This just happened within the last month, I think.
Yeah, 2 weeks ago.
Yeah, so it's still early days if we're thinking about the analogy, both in terms of substance and a timeline. But with what else we're seeing in state houses around the country, I wouldn't be horribly surprised, as I said, to see copycats.
Yeah, no, it's very easy to draft a model bill and then one legislative session later, it's in 10, 15, 20 states.
Just to add one other point, we've been talking about civil liability. I don't know if folks like going to jail. But there are criminal libel laws in the United States still. Several states have repealed their criminal libel laws, but there are indeed criminal libel laws in the United States. And indeed, individuals who criticize their police departments have been arrested for criticizing their police departments. The Supreme Court, in a case called Garrison versus Louisiana, placed the actual malice limitation on criminal defamation as well. But if Sullivan were to fall, I don't know why. I mean, nothing's stopping a legislature from either the law is either still on the books or passing a new criminal libel law and just throwing people into jail again because they have unpopular opinions. So it's not just a civil issue.
Okay, so the moment everyone's been waiting for, prediction time. Is the Supreme Court going to modify or overrule New York Times versus Sullivan? And if it does, what do you think takes its place?
Well, I already gave you a preview. I don't think that there are 4 votes to hear arguments on whether Sullivan should be revisited. And even with Gorsuch and Thomas, neither one has really directly attacked the public figure rule of Sullivan itself. It seems like there's more interest in chipping away at the doctrine that came later. I think, Sullivan is going to stand for the immediate future, I would say, for as long as I foresee practicing, I hope. However, if you asked me about Roe v. Wade 10 years ago, I probably would have said the same. So I'll leave my prediction for the near term.
And I'm involved in some high-profile litigation involving actual malice as a key issue, so I'm going to stay quiet on this one.
So I agree. If anything, there would be some trimming along the edges with public figures and maybe trying to constrain some of that doctrine that's been extended in lower courts over the years. Two things. I'm not even sure if there's support for that, though. Justice Alito, in what is probably the best defense of freedom of speech from the Supreme Court in the last 20 years, wrote an opinion in National Review versus Mann. It was one of these things that I tossed aside as a judicial op-ed earlier, but now I'm going to invoke it. It was a really good op-ed. So in that case, it's brought by a climate scientist against National Review, and the concern is that it essentially turns into a trial whether or not climate change is man-made or real or what have you. Again, I'd suggest that these aren't issues that we should not have Scopes trial after Scopes trial. These are not issues that should be decided by a judge or a jury. So at any rate, I have hope that because of opinions like that, I don't know how, for example, Justice Alito, he's a justice, he can do what he wants, would turn around and say, well, we can cast aside Sullivan. That seems unlikely. And I also appreciate it because it demonstrates that commitments to freedom of speech, freedom of press are not just, it's not just the liberal media, once again, right? Like that this should be a nonpartisan issue. And then finally, a colleague and I, Jeff Kossoff at the Naval Academy, who, when we speak together, he always has to say, I do not speak on behalf of the Defense Department, which gives me a chance to say, I too do not speak on behalf of the Defense Department. But he and I wrote a law review article suggesting, we have a statute at the back of the law review article that would codify certain baselines for defamation standards. It would preempt state law defamation standards anytime a defamation is transmitted via interstate commerce, right? So broadcast, internet, what have you, when it obviously reached purely local defamations. but he and I have suggested let us stop, wondering what will happen at the Supreme Court and just have Congress on a nonpartisan basis pass a law that sets minimum baselines so we can move past this and actually get to the reason why we should all be participating in our democracy, which is to say to discuss the important issues of the day. So I would hope that Congress would come together and pass something like that. I have hope because, for example, we talked about other countries' laws. Back in 2010, on a bipartisan basis, Congress passed the Speech Act, which essentially said if a country does not provide as much protection as the U.S. does in its defamation law, then courts in the United States will not enforce those foreign judgments here. So indeed, speech can be a bipartisan, nonpartisan even issue. But that was 13 years ago. Maybe times have changed. I don't know.
Well, I think the only thing to add to that, for better or for worse, Justice Thomas and Justice Gorsuch want to overturn a lot of opinions, and they usually don't get their way. So until you see other justices starting to join on, I don't know that I would predict any rapid movement on the Supreme Court's part.
I will, just to add really briefly, there is one thing that's always been concerning to me and others, which is to say Justice Kagan, back in the 90s, wrote a law review article about, it was actually a book review, law review article, about New York Times versus Sullivan, and she had suggested in that article that the court had, while Sullivan seemed right, that the court may have gone too far in extending its principles. So who knows, maybe there's bipartisanship on both sides of the issue.
Well, she certainly didn't walk it back in her confirmation hearings.
Yeah.
So.
Well, at this point, I'd like to open it up to the audience for questions. We've got one right here.
So we need a microphone. Where that went?
You
Will
want
you take
mine?
mine? I won't be talking.
You can keep it.
Someone needs to take my mic away.
Otherwise, folks on the live stream can't hear.
Check 1 2. Okay. I'm Dan Mike. I'm a grad student in the journalism school. Before my question, I want to say thank you to the journalism school and the law school for this. Also, congratulations on some very good timing as we are having a discussion about NYT versus Sullivan and defamation law, as we are just weeks after the Dominion lawsuit against Fox News started to release tranches of communications, essentially saying that Fox News hosts privately were saying that a lot of their guests saying that the 2020 election was stolen and so on and so forth. Privately was saying that these sources are not reliable, and then putting them on anyway and posting them as true. And I believe the current figure that Dominion is suing for is 1.6 billion or so. So I'd love to get your opinions on or your thoughts on that part of the information we've seen so far. And then also Fox News' public statement saying that ultimately this case is going to boil down to the defenses that they have under NYT versus Sullivan, and their arguments that fundamentally this is a case that is trying to chill their freedom of speech.
Alexandra?
I actually don't think I am able to discuss that matter, but.
Okay. I'm not either.
So I guess that
leaves
me. So I will just say this. Two things. One, we're not operating on people. Like, defamation law is not that complicated. And in that way, I actually think that the Fox versus Dominion or vice versa, is just kind of like a rote defamation case, like any other defamation case. I will say that what matters is not a kind of like a general acknowledgement over here, maybe that somewhat maybe suggests, right, that they were acting with actual malice. You have to look at every defamation claim centered on a particular statement. So in a complaint, a defamation plaintiff, if they do it well, will, in listing all of the various elements they have to plead, they'll attack a particular statement. And what they'll eventually have to show is that particular statement was made with knowledge of falsity or high degree of awareness of probable falsity. So, kind of the general, and I will say I've not even read the Fox briefing, which was why I'm not going to, offer anything more substantive. But the kind of general sort of headlines of like, oh, X person said this, does not necessarily translate to in kind of the formalities of the legal system of, oh, that means it's totally actual malice. It'll have to be done on a statement by statement basis. And it'll have to include as well, of course, defenses like whether or not there was, some sort of neutral report or opinion or what have you, right? Because to go back to what we were saying earlier, like most cases aren't resolved on actual malice anyway. So I don't know if that's horribly responsive, but hopefully that's helpful.
Well done. Thanks. With respect to the Gertz opinion, what do you think about Nicholas Sandman? He was someone who was no one and got all of this abuse. And the question is, well, should he have some kind of remedy? And who should it be against, if any?
I think that's a great question. And one of the things that becomes really challenging when we're talking about defamation today and we're talking about how these cases unfold and breathing space and the chilling effect is the way in which stories unfold, right? And the Nicholas Sandman case was a really interesting case in that oftentimes now in newsrooms, we're getting stories based on what's happening and what's being posted on social media. And so one of the real issues that you have to think about, and one of the things that the court was concerned about in Gertz, is that a plaintiff who was covered in the news after the event, that alone would not make them a public figure. Right, and so one of the really interesting things when you get into the pleadings and the information in the Nicholas Sandman case is seeing exactly how that unfolded. And, before the Washington Post put their video up, how much coverage had it had on social media? And the very granular approach to having to do that is one of the reasons, as Alexandra suggested, that discovery can be so expensive. Is really trying to figure out when does that switch flip, and where was the alleged defamatory statement in comparison time-wise to when that switch flipped. Without naming particular news organizations, I will say I certainly think there were some claims where Mr. Sandman had a much stronger claim that he was a private person, and there were some instances where I think it was much clearer that he was a limited purpose public figure after the story had broken.
I didn't see any other hands, so I'll ask. Stop.
Here. So the standard here strikes a balance between protecting reputational interests and free speech interests, right? A strict liability regime is fully protective of reputational interests and not free speech, and a regime where we didn't have defamation suits would only protect free speech interests. And
that would be the Justice Black regime.
Okay. So here we have something in between, and we hear all of you wanting to be on the side of protecting the free speech interests, I think. I'm wondering if you think New York Times versus Sullivan protects speech interests enough. I'm wondering why do you think it would be better if it had a purpose standard, meaning a plaintiff could not be successful unless it was shown that the speaker purposely tried to harm the reputation. So is Sullivan strong enough?
So it's what we have, obviously. So far be it from me to speak ill of it, but I think there were probably better ways to do it. I think things like caps on damages makes a lot of sense, frankly. The problem with focusing on fault is it increases the cost on the defendant. So how does it do that? Discovery first and foremost, right? Because if your fault matters, then all of a sudden it's, give me all of your communications that you might have had that in any way relate to this story, or maybe like you have a family member who has some sort of like beef with the person, and then it's discovery into that, all in an attempt to try to make out this fault showing. And in a way, it's disadvantageous to the media or to any defamation defendant. So I think something like, a cap on damages without the actual malice standard would go a long way to kind of resetting that balance. But I'm at least not yet willing to advocate for overruling Sullivan.
Got a question in the back?
I wondered if we should be thinking of this as a trade-off between reputational interests and speech interests, where speech interests are only on one side. If libel is power, then we are requiring ordinary citizens to give up a very powerful tool in order to enter the public debate on subjects of interest. I say this not to say we should get rid of the actual malice standard, but just to question whether these policy considerations are a reliable guide if there are unintended consequences of chilling speech because in order to enter the public debate, you have to give up a protection.
So I guess, are you saying you have to give up the risk of preserving your reputation, or what are you saying that you have to give up?
You have to give up your right to sue someone who defames you, which is a powerful tool.
Right, it is a powerful tool, but I think there are other ways outside of the court system to defend your reputation and protect against these sorts of harms. I mean, one of the themes of the Sullivan lines of cases is maybe the courts aren't the best place to duke out the truth of something or restore someone's reputation. I'm thinking of, there was this case back in the 80s, Westmoreland versus CBS, and there was this fight over whether there should be cameras in the courtroom. Ultimately, it was decided on rules grounds that no, that would not happen. But the trial court judge was actually very taken by CNN's argument to have cameras in the courtroom and said, the judgment here is not actually what's going to matter to the plaintiff. It's having the public be able to determine, okay, did CBS properly report this or not, and then come to their own determination. And I think that when we talk about reputational harms, I mean, we really should be thinking about the remedy. I mean, is the remedy of damages really what could restore your reputation, or is it something else? So I don't know that you necessarily have to forsake your reputation and the right to ultimately restore it, entering the public sphere in a regime where Sullivan doesn't exist. I think there are better ways to go about it.
And I'll just add very briefly, there was, precisely to your point, in the 19th century, there was this idea that if public officials were put to having to prove a higher burden, then perhaps they just won't run for elected office, right? Because why would anyone give up this power, as you mentioned? Ultimately, in the course of this country's history, at least, that idea was rejected and said basically, one, there's no evidence that people are actually not entering public service because of, the hypothetical chance that in a year or two they might get defamed. But then secondarily, our history from the revolution until now, I mean, for example, James Kent, a scholar in the 19th century, said there would not have been a revolution without defamation, right? Like, our history is this idea of speaking critically of those who are in elected office. I know that doesn't get to the public figure point, but just wanted to add that historical.
So unfortunately, we are out of time, so please join me in thanking the panelists for today's wonderful discussion.